here's the story. That's what I did for a number of years, is just fight these people. Worked for a number of Fortune 50 companies doing that, and there's one in particular, and I was working for Playboy, which, funny enough, the pornography industry is one of the most advanced DRM rights management groups in the world, and they have come up with just incredible technology. They've basically driven all of DRM technology because, of course, you know, they've got to protect their stuff. And so they've got, you know, all this technology that they're using every day for, you know, the stuff that they do. Well, one of these groups sued them for, you know, a whole bunch of infringement. And it's funny because we actually we did a bunch of discovery, found out how big this non-practicing entity was. There's one man who owns this non-practicing entity, and he's got an army of lawyers underneath him, and he's made enough money to where he has a bigger house than New Bedford. And it blows my mind, because he's just some quiet little engineering guy from West Texas, and he's made hundreds and hundreds and hundreds of millions of dollars doing nothing but hiring attorneys to sue companies. So that's just an example of, you know, the patent system being a little bit broken. And that's why you'll hear in the news that Congress is working really, really hard, so I'm sure it's going to take 30 years, working really, really hard on coming up with laws that restrict the rights of people who have patents that don't actually practice them.
On that same note, whenever they do sue, they own the license and then fees, and they sue somebody, whenever they win, they're aware of fees that they pay that company as well, right?
It depends. They're going to argue for that, but it's probably 0.1% of cases that get to that point. You know, you have seen, if you guys have ever bought anything from Newegg, bought any computer stuff from Newegg before, they're one of the few companies that actually will take a non-practicing, and they have, one that owned a shopping cart patent for an electronic shopping cart, have taken those companies to the mat. But that almost never happens, because even as a large company, if you're an IBM or a Google or a Samsung or whatever, you don't want to duke that out. It's gonna take you less money to just pay somebody than it is for you to actually take that all the way to the very end. And even if you know it's bogus, even if you know that, you know, that patent is going to be invalidated and that there's no chance that, you know, they're going to win this trial, you will spend 4 or 5 times more money on that trial than you will on just paying the licensing fee. And they actually figure that out. And they say, okay, well, how much will this large company expect to spend? Okay, well, we're going to offer to license them to them for 1/10 of that. So they're, you know, that's how they work. Yeah, until probably the last 15 years of massive fights in the tech industry, it wasn't, I mean, it was always a role, but not a huge role. But now you have large companies like the ones I just mentioned, like Google, like Apple, like Samsung, that will go out and purchase companies solely to get their intellectual property, which is very interesting. I mean, it's not, as a startup, it's not something that you would pursue. It's not like, oh, I'm going to get bought by this company, so I'm going to go spend, you know, $100,000 on a patent. But absolutely, that's a huge role nowadays with big companies amassing patents, really to protect themselves, not just from NPEs, but from other companies. Yeah.
I was going to say, I think that's a huge role. It's a growing area of the law. We see it happening because it's more and more. I think both Trey and I have stressed that anymore, a lot of companies that we deal, it's cheaper for companies to go out and buy startups than doing their own internal R&D. I don't know if any of you have seen on HBO, they just started a new show, Mike Judge, Silicon Valley. But the last 2 episodes, they've sort of been dealing with that, where these bigger companies will go in and they'll buy startups. And they might have a completely opposite intention of what they want from that startup, like the technology, because of copyrights, because of coding, because of patents. And they want to use it for entirely different means, but it's cheaper for them to go in and bully these startups and buy them out. The startups are happening depending on where you sit as, I guess, a founder of a startup, whether you're getting bought out, how you negotiate with them. But it's having a much bigger impact, a huge role.
So, in that exact example, where a small company spent a lot of money to develop a technology that a bigger company wants, That's kind of the counterpoint I was getting to earlier, is that that's why patent law gives you those strong rights of monopoly and injunction. It's to protect those guys. And so is that little guy, he's never going to play in that big market. But he spent a lot of money and time on this, and the law says he has a monopoly. Well, he's a non-practicing entity. He's the same thing that he just said was a patent troll. So he's not in that market. Or say he tries and tries to get in the market and spends all his money and never has enough sales because he doesn't have a big sales force. So the law gives him a way to still get some value out of his patent, which is to sell it to a larger company or to sell it to a non-practicing entity. So who knows what a patent troll is when you really get down to it. The guys who created that term were a bunch of Intel lawyers here in town. So they got sued for using the term patent extortionist. And they decided, and they lost that suit, so they decided to come up with a better word for a patent extortionist, and they created the term patent troll. And they said it was someone who sits under the bridge of innovation and tries to extort a toll from all those who would cross. The Billy Goat Gruff, exactly.
Can you touch a little bit on reverse engineering and just when you're a startup going up against one of these bigger companies who wants to buy?
Oh, sure, yeah. So that company, most products you can buy them in the market, and especially the bigger companies have an R&D lab that can tear it apart and reverse engineer it and get everything they need out of that without licensing it from the inventor. So the patent law is really strong in favor of the inventor in that case. And it lets him sue them for infringement if they actually reverse engineer and then they build a product that has the same things in the patent. Well, he still has the right to do that, even though he's not selling in the market. So he can sue them and get a reasonable royalty from them. Well, he can't get the biggest damages you can get are lost profits. If you're not selling a product, well, there's some protection for the company. They don't have to get all their profits. But he can still get a reasonable royalty under the law from them if they reverse engineer his technology and start selling a product that infringes the patent. So there's kind of a flip side to this. The law was, the Constitution is the foundation of U.S. patent law, and it said, we secure to respective inventors and scientists the exclusive rights to their discoveries. So the idea is that it would give them exclusive rights. It wasn't to pay them a profit, but really the only way in certain cases to let them have exclusive rights, especially when they don't have money to develop it, is for there to be some way to sue and license and do all that, is to create a market for intellectual property. So without the right to go out and sue someone for infringing a patent, there's no market for IP. They would just copy it. Right? They would just copy any patent that, if it's not being exploited at the time, they would just copy it. So it's really hard to craft a law that stops all this unfair patent troll litigation, but at the same time protects all those small inventors and the labs, which are most of U.S. tech companies, by the way. There's something like 250,000 tech companies in the U.S., and most of them don't have a big budget at all, and they're very dependent on their patent rights. So we had a question.
So there used to be, I guess, kind of like a sorting or return that maybe one thing patented, you just print it out, put it in an envelope and mail it.
The poor man's patent, yes. My brother did that. He mailed one to me. He says, it's better because you're a patent attorney, right? No, it's not. So that law, that was based on proving invention dates. So the law used to be in the U.S. that the first to invent got the patent, which seems very fair. So everybody would write it down and you would get witnesses to sign it. And so the poor man's patent would be, it's, all you need is a witness to sign it. You don't need a postmark on it. There's no extra value in getting the postmark. But yeah, that used to be the law. It's no longer the case. As of the American Invents Act a few years ago, it's now the first to file, and there's really no benefit to doing that.
Yeah, so, I mean, even the poor man's patent, it will, as he mentioned, it gives you it lets you put your flag in the ground and say, I created this then, I've got proof, or what a lot of, my people do, they'll send me an email and they'll detail what this thing is, and they'll say, okay, so now we've got that, it's on the server, it's saved, it's got a date, we're good. But the problem, of course, is patent law doesn't just care about who invented it first, and even before we changed the law to where it's now first inventor to file, even when it was first to invent, the idea is you're giving protection over something that's not available in the public. If somebody did that, if somebody came up with a four-wheeled human transport vehicle and sent them a letter and said, here you go, and then it became publicly known how to create that exact same invention all over the world for a period of time, then it wouldn't really matter. you would have lost that right because it's in the public domain, so you can't patent something in the public domain. But now, as you mentioned, with the patent reform that we've pushed through, it's now first inventor to file. Everybody else in the world, kind of like the metric system versus the old English system, everybody else in the world, just about, aside from a couple of our allies, has what's called a first to file system. And what that means is whoever files the patent first gets the rights. And so, as you can imagine, it's pretty easy. It's who showed up the door first. Okay, well, then you get the rights if you can file for it and prove it. We had what was called a first to invent system, which basically means if you can prove that you invented it first and you fulfill all the other requirements, then you get it. And of course, that leads to these massive, massive fights in the patent office. Well, I created first. No, I created first. Well, here's my proof. Well, here's my proof. Let's go through this giant proceeding to try to figure out who created this first. So that was a big problem in the patent office. And of course, a lot of other countries are like, I cannot believe we have to do business this way when almost every other country we work with doesn't do it like this. So, and this is something that I did a little bit of work on doing law harmonization, but we finally said, okay, well, we'll compromise. So we now have a first inventor to file system, which means you still have to prove invention, but we're going to short circuit that giant fight in the patent office and say, if two people said that they both invented it, it's the first one that told us they did and can prove that they did, gets the patent now. I'm about to have to head out, so I will actually give you guys a little bit of advice, and I'll talk briefly about patent versus trade secret too. We've talked about how expensive patents are. It sounds really scary. Why in the world would you want to get one? And generally you don't, because they're not always a profitable thing. It's just going to be part of your calculation as a company and how you want to secure your rights. There's two things that you can think about though that will allow you to kind of get into that space easier, and one of those is a provisional patent filing. What a provisional filing allows you to do is place a stake in the ground relatively cheaply and then go try out your idea. So you'll still have to draft a patent, and generally what I tell my clients is, let's draft the whole thing, as if we were going to file it, because there are some requirements that you actually have to disclose in the provisional filing what you're going to try to claim. But if you file a provisional patent, it's cheap, it's $100, and it gives you a year in which to test out your idea, to market test it, to see if it's going to work, and if it does, then within that year period, you file your formal patent, and you go through the patent proceedings, and the patent office will say, okay, we're going to give you this priority date, which is the date you stuck your flag on the ground. So, okay, even if in that year, while you were testing out your product, maybe somebody else came up with the exact same thing, you're safe because you filed this provisional patent. So particularly if you don't have a lot of money, it could be a great way for you as a small inventor to try something out, and you're probably still going to have to spend a good bit of money to get somebody to draft it, because what you hate is to try it out for a year and then say, oh, this has nothing, you filed this patent on a bicycle, but you're trying to get a car now, so we're not going to give you that right. But it's a great way to do it more cheaply. The other thing to touch on too is, and I'm sure we'll talk about this more after I'm gone, but is trade secret. So, maybe you don't want to file a patent either because it's too expensive, because you don't think you're going to get it, or, for any of a number of reasons. Patent law requires you to disclose to everybody in the whole world about, everything about your idea, what the best way is to do it and everything else. Well, you can always do what's called a trade secret, which is you hold that information close to your chest, you keep it confidential, you don't share it with anybody, and if you do share it with anybody, then you make them sign non-disclosure and confidentiality agreements and whatnot, and it is a private company secret that you have. So if you've got a great way to create this drug, you may, and nobody else is going to come up with it, then you may not want to patent it because it may be extremely expensive to do so. A lot of tech companies, because of how fast technology moves, they won't actually patent something. They'll just keep it as a trade secret because in 6 months, it's probably going to be outdated anyways. And so that doesn't require you to do anything aside from maintain the confidentiality of your idea. You don't have to file anything, you don't have to do anything like that. And then when it comes to somebody down the line who maybe an employee who left your company or somebody disclosed something or whatnot, then you would sue on that and you claim it's a trade secret and go through that process. So just some practical stuff. So.
For many years, I advise people to go ahead and file a patent, and very rarely would I say trade secret. But nowadays, there's this thing called code obfuscation, where when you write software, you can encrypt that software, and when you run it, it's decrypted on the fly, and then it's used. So that's a way, if you do that properly, you meet the trade secret laws. So in many cases nowadays, I would tell people to do a trade secret for their software instead of trying to do a patent, because it's getting harder to get a software patent, and you have these stronger ways in technology to protect your secrets. So that's definitely an important thing for tech companies, especially software companies. Other companies, drug companies, chemical, biology, lots of trade secrets in those areas.
Yeah, I might have a chance for a question before I cut out.
How does all of this interact with collaboration with your technology? For example, GitHub is something very popular, for people to use, say, for their coding projects. So let's say they're pulling in things with different licenses, and let's say part of my code is proprietary, but part of my code came from an open source project. Can I still file a patent on that code?
It depends. You wouldn't be able to file a patent on the entire thing,
Yeah.
but your proprietary code, if it does something special, something unique, something novel, something non-obvious, you might be able to file for that part of the product. You can get a copyright for your code, assuming that you created it originally, nobody else created it. You couldn't get one for the entire product. And you might be able to, let's say, for instance, that it's much harder nowadays than it used to be, but you could potentially get a patent on the part of your product that you created yourself. So, but not the whole thing.
You're much better served than that thing is to rely on copyright code, especially something where you're talking about a collaborative matter.
What's the difference in protection from the point where your patent is pending and where the patent is actually accepted?
While the patent's pending, you don't have it.
So would that be the most relevant for like the first to file?
Yeah, I mean, you guys will see on, because it's such a long pipeline to get a patent, you'll see on stuff, everything from cups to, to software to whatever, you'll see patent pending on there. And, patents are going to take 3, 4, 5 years to go through, and so you'll see that on a lot of products. I mean, the moment you get it, what they care about, let's say you get the patent, then it's going to be valid from the date that you got it, you filed for it. So, you can protect it from that. So, like, let's say that you are, and there's a whole thing that Tyson, you probably talk about submarine patents, but you file for it on day 0 and you get it 4 years later. So 2 years into that, somebody else started doing something that was just like what you filed a patent for. I mean, you could go back as soon as you got that patent and you could go sue that person. Absolutely, require them to license it and everything else. But while it's pending, you won't have a patent.
When you file a patent, from the day you file it, it publishes 18 months later, and so it's available to everyone. So the rights you get with a patent are the claims, and they're at the end of a patent. And so one of your competitors, when you file a patent, can look at the claims, and they can see whether or not what they're doing would be covered by your patent if it were to issue as a final patent. During the process of you getting the patent, you go back and forth with the patent office and the claims can change a little bit. When you finally get a patent at that point, one of your competitors could have already started investing money and putting money into it, and you can sue them and basically destroy everything that they were working on. So you filing a patent, you don't have any rights, but you are putting other people on notice. And you could possibly leverage that for, if someone was really interested in it, they could go to you for a license, or they could look to fund a portion of your patent, create a business opportunity. The other part is along the way that eventually when your patent is getting ready to file, your claims are somewhat determined, and before the patent issues, you can put your competitors on notice, and you can say, hey, I have this patent, these claims are going to be issued, and once your patent issues, in some cases, you can actually retroactively go back for a certain period of time and get additional damages. So the patent pending status, if you ultimately end up getting a patent, having that in the pipeline is actually something that you can use and leverage. But no, there are no rights that you can actually enforce until you get the patent.
The words patent pending they're pretty powerful in the tech industry. Since, like we said, 95% of patents are defensive in nature. Well, that patent pending starts to scare off your competitors already. So you get some of that benefit already. You get the patent damages in some cases.
And now that Austin's gone and I have the microphone, we're going to return to the topic of non-practicing entities for a second. I will make this very short. For non-practicing entities, the situation Austin was talking about where one person went out and acquired patents and was going around to different industries, to different companies, and asserting them. When understanding patent trolls and patents and non-practicing entities, single people will go out and solo inventors will go out and get patents, and they do not recoup their costs. So eventually, in order to try and make some money or recover their costs in some way, they have patent auctions. And people go out and they say, hey, I have a patent, I'm willing to sell it at an auction, and whoever wants to buy it can get the rights. So there's a marketplace. Patents are valuable. They're a commodity. And for someone then to go out and say, hey, I'm an engineer, I'm a smart businessman, I see value in that patent. I can acquire it, and then I can go and enforce it. It's part of America to a certain extent. I mean, it's a free market society, so because that one person sees value and is able to use that patent and extract value from it, large companies find it as a nuisance. However, there was a patent auction. The large company, had they evaluated that patent properly, had the same opportunity to go out and purchase it. And actually, one of the things that's happening now in terms of trying to change the law to make it harder for patent trolls to enforce a patent, one of the other strategies that large companies are doing right now is large Fortune 100, Fortune 500 companies are pooling their resources, and now they're actually going out to patent auctions, and they're buying as many patents as they can to limit the amount of patents that are available for patent trolls. And what they will do then is they will buy as many patents as they can, and they will cross-license it to all these patents to each other. So now if a non-practicing entity or a small business comes to them, all these larger companies have more patents that they can use to assert against the other sides. So there's a whole business, there's a whole strategy, and when you hear about patent trolls, it's not necessarily that these guys are just going out and that they didn't come up with anything. Well, someone came up with something and they saw value in it. So there's a flip side to it as well. And some of the conversations about changing the law to make it harder for patent trolls, like you have to be a practicing entity. They're talking about having to basically put it into escrow $1 million or $2 million to be able to enforce patent rights that you have legally. So basically, to try to address patent trolls right now, one of the ideas is to make it more difficult for people to get into the court system, which seems to go against everything that the American legal system and judicial system is about. But, so you'll hear various things, and just know that there's multiple sides to this issue. And I guess we'll have one question and then get to copyright.
Well, he asserted that these patents they're holding are not valid in some way, like maybe that they're not actually non-obvious. Is that true?
So they have an issued patent. However, during the process of a litigation, you can basically go and invalidate a patent. Say, all right, the patent office issued you this patent. They said it was new. They said it was non-obvious, but no one brought up this document over here. And based on this document, it shows everything that the patent does. And the court will say, okay, the patent's invalid. But to get to that process in a litigation can cost a couple $1 million. So that's where it's, all right, possibly we could go through the legal process in the litigation, and the goal would be to invalidate your patent. But in order to do that, it would cost us $5 million. You're just looking for $10 million or $10,000 a year for the next 5 years. All right, $5 million to invalidate your patent, or $50,000 to make you go away. So it ultimately comes down to a business decision in a lot of cases. So, but part of the niche then of a patent troll who's good and who's successful is buying the right patents, evaluating the value of them, and offering licenses for what he thinks he can get, and knowing that he can get the amount of money out that they're worth. So.
Yeah, I would agree. Most of the talk you see in the media about patent trolls is very, very large tech companies who they want to be protected from lawsuits from inventors. So like I said, the guys who came up with the term at Intel, one of those lawyers is actually now at Intellectual Ventures, the big patent troll that Austin was talking about. So you have to just listen to who's talking, whether, what interest they have in the situation before you. Because I think we're going to have a lot of reforms in this next wave of the law that really hurt small inventors. And the only thing they favor is the big industrial research labs, the Fortune 500 companies. But that's not really the source of innovation in the U.S. And what makes American tech companies the world leaders and gives America such an advantage is the small tech companies. So there's a lot of controversy in this area, but I think it's about where it needs to be right now. I think more reforms are probably going to hurt small companies more than they're going to help the problem of patent trolls.
We go till what, 6:15?
Yeah.
All right, I'm going to do it the best I can to try to teach about copyrights in 30 minutes. Usually I teach this class over at the architecture school. For an introductory, I usually do it an hour and a half, so try to cut some corners here. The main thing, I'll try to put this in terms of take-homes so that you get the main points on it. The big thing that copyright protects is it does not protect the idea. People talk about, hey, that's my idea. You're infringing my copyright. No. Copyright protects the original expression of the idea within certain categories that we'll talk about in a minute. So you can have an idea, that's not protected. You want to protect your idea, go see the patent holders. Okay? But it's how you express that idea that is fixed in a tangible medium of expression within the categories that are protected. What's protected for copyright? Literary works. Things, for example, poetry, novels. By historical accident, software is considered to be a literary work because it's written down. You can't understand it because it's in binary, but nevertheless, code is considered to be a literary work. Visual works, photography, drawings, paintings, sculptural works, and by that it means actual sculpture. You can't take a useful object like a table and say, oh no, that's really a sculptural work. No, it's a useful article. If you want to protect a useful article, once again, go see the patent lawyers. But if it is an original thing, it can be a sculptural thing. Architectural works, and there's a whole story on why that's changed in the last few decades. It'll have to remain on the cutting room floor today. Choreographic works, the way that you've laid out a dance, that can be done. Audiovisual works, namely movies, you put all this together. And of course, musical works, both the composition and the actual performance of this. These are the things that are covered by copyrights. Now, again, the main thing to focus on is it's what you've now fixed in a tangible medium of expression. If I sit here, and usually when I do this, I've got a blackboard. If I take a piece of chalk and I draw a daisy on there, okay, congratulations, I have just created a visual work. Is it protected by copyright from that moment? Now that it's fixed in a tangible expression, yes, I have a copyright in this. What does that now give me as the author, the person who fixed that expression in a tangible medium of expression? What does that give me? It gives me the right to exclude others from doing certain things. And these are known as the exclusive rights. The big one is the ability to make copies of it, what is known as the reproduction right or the copyright, hence the term. It also includes the right to vend. In other words, I have the exclusive right to sell or license other people to make copies of my work. And that's the real money where it comes in copyright laws. Who's got the right to sell or to authorize the selling of copies of the work? Now, where copyright can really get away from patent law is in the next one, which is the derivative works right. And that is the right to control the creation of derivative works. If you will, sequels. If I've got the right to Iron Man, I also have the exclusive right to who's going to make Iron Man 2, Iron Man 3, Iron Man 4. This is different from patent law, because in patent you're strictly limited to your claims. Now, you can then have people, and they do this, what they call is a design around, in which you basically figure out, okay, how can I take this invention, and I'm going to change it so that it no longer reads on the claims. I've designed around it so it no longer meets up with all these claims. I had an architectural case a number of years ago where we knew from an inside source that a developer had taken one of my clients' apartment project plans, taken it in-house and redrew it. And, we had someone think them out, and we then threatened to sue them. They wanted to sit down, and they were represented by a patent lawyer. And he rolled out the plans and said, oh, but you see how we changed this, and we changed this, and we changed this, and it no longer reads on your plan. And I looked at him and I said, thank you. You just confessed to making a derivative work. We'll see you in court. And ultimately, they wound up having to pay a very tidy sum over that. So the fact that you modify a copyrighted work doesn't get you away from infringement, because one of the exclusive rights is the right to control the creation of derivative works. If you're the author and you own the copyright, you have that as one of your express rights. Okay, this is very, very high level. We can get into a lot of detail on this. Who owns the copyright? The copyright originally vests in the author, the person who actually fixes it in a tangible medium of expression. Okay? Now, two big exceptions to that. One of them is if you are an employee, and by that I mean someone who is, you're employed by someone, they're paying your Social Security, they're telling you what to do. No funny business here, someone that's a real employee. In that case, if what you're doing was within the course and scope of your employment, then your employer owns the copyright. So, if you're a draftsman and you're working at an architecture firm and you create a set of plans, if that's what they were paying you to do and you're their legitimate employee, they own the copyright, not you. Okay? The other one is what's known as a work for hire. And that can be a situation where parties sign an agreement saying that for purposes of this, what you're doing is a work for hire and I own the copyright. Well, let me tell you something. Work for hire contracts, you see the language out there, I would just tell you, if you're an entrepreneur and you're wanting to get rights in something, do not use a work for hire contract. Because there's some technical aspects of them. They're only applicable to certain categories of work. They are also, for example, if you use work for hire language in a contract in California, that person becomes your employee for all purposes, including payment of unemployment compensation and everything else. And if you think the Franchise Tax Board in California won't come after you, you're kidding yourself. The main thing is if you need to get the rights from somebody, and by that I mean full ownership of the copyright, don't use work for hire language, just get an assignment. In a copyright assignment, it's governed by 204A. It's very easy. All you got to do is get a writing signed by the copyright owner that basically says, I give you all the rights. That's all you need. but you have to have it, it will not be implied, yeah.
So let's say you're working on a novel, and you get hired by a company that does publishing. And the time you're working for them, you're also working on this literary piece. While you're working for them, you finish the book and you want to get it published. Does a part of that book belong to them now, or do you still retain all of it because?
It depends on what your, it depends entirely on what your job is for. If you're working for the publishing company as a receptionist, probably not. If they're hiring you to come up with and write novels for them, maybe so. Again, that's one where I'd say more data needed. Again, a lot of times if you had already started it before, probably you're going to get there. But again, if you're working for a publishing company, I don't know too many publishing companies that have authors on staff that are hired to write books.
Well, no, I mean, you're working for a publishing company, let's say marketing, but you're doing your own kind of side.
Probably not, because what you're going to be focusing on is whether or not it's within the course and scope of your employment. And if you're working on marketing, writing novels is not within the course and scope of your employment. Now, again, someone pointed out in an earlier conversation, they may have an employment agreement that says everything you do from the time that you're employed, doesn't matter what it is, belongs to us. If they do that, then they may very well.
That's a mistake, that's a contract issue.
It's going to be a contract issue, absolutely.
Usually when you're taking a job, you identify, I've got this job I'm working on. Identify with them and negotiate it. You're not gonna have a problem. But you gotta be explicit about it.
We do that, not everyone else does that.
Okay, so let's put a real world thing on this. And again, remember that copyright's going to belong to the person that has. If you use it and you don't have either, you haven't even acquired the copyright or you've not gotten permission, a license, and licenses can be either express or they can be implied for conduct, they can be in other things. But if you don't have some type of permission to use it, then if you reproduce, make a derivative, or sell a copy of the work, you're committing copyright infringement. And as we'll talk about in a little bit, the remedies for it are truly scary because the law is really loaded against infringers. Now, say you've got a business and you're setting up a website, okay? And, okay, you hire a web company and you say, okay, put together a website for me. And they come back and they bring you and they show you some neat stuff and it's got all these nice photographs and it's got a music track and you've got all this graphics. And you say, okay, that looks really great. Here's the $5,000 I promised you when your website goes live. And then you start getting demand letters from a photographer who says, that's my photograph, I never authorized it. From ASCAP who says, oh, that music is off of this and we never authorized this. Or even from a graphics company that says, hey, look, they contracted with us to design this website and then they never paid us. And you're using our intellectual property having never fulfilled the condition preceding in our contract. And you're guilty of infringement on all 3 counts. And you're going, wait a minute, but I didn't know any of this. I hired the webmaster over there. And this becomes the next big take-home. Copyright liability is a strict liability statute. You don't have to intend to commit copyright infringement. If you accidentally infringe somebody, too bad. If someone even defrauded you into infringing, too bad. Now, it may help in terms of what remedies go against you, but in terms of whether or not you have committed an act of copyright infringement, your state of mind is irrelevant. It is a strict liability statute. It can get really scary because, again, think about that situation I just described where you've hired a webmaster who you thought was going to take care of everything. And they don't authorize, they don't cross all the T's, they just grab stuff. And suddenly you're now on the hook. It can happen and it does. Yeah.
Is there legal recourse to go after that person to transfer that ownership of the infringement on the webmaster? Did that do?
I mean, you can sue them for breach of contract or DTPA or whatever else, but in terms of can you say, I'm not liable, they are? No, it's going to be your liable, and then you're going to have to find somebody, you're going to have to find a way to lay off that on them, but you may have to be the one that pays first. I'll give you an example. This is a case I had a couple of years ago. One of my clients is not familiar with Houston, but in one of his previous careers was a very celebrated art photographer down in Mexico. And he did a book on tequila, and the cover piece was this iconic photograph of him chopping the agave plant. And it was exhibited in a couple of museums in Europe, and I think in one of the museums in New York. Beautiful picture. Okay, well, fast forward 20 years, and he's walking through Specs downtown in Houston, and all of a sudden he goes, what? There is an entire line of tequila from a small distiller in Mexico, and their entire brand identity is built around that image. I mean, it's on the label, it's on the boxes, it's embossed into the damn bottles themselves, it's in all their advertising, and of course, he had no knowledge of this. So he calls me, and I, of course, contact the distributor in the U.S., saying basically, what is this? And they're like, well, we're just a distributor. We'll get in touch. And they contacted the distiller, who said, hey, I hired an art guy in Oaxaca, and he told me we didn't know about any of this. And so they're like, well, we didn't know, so let's work something out. And I was like, okay, well, let's see, what can I do to these guys? Okay, well, under the copyright laws, of course, we could go for our actual damages, which would be, okay, what would the license be for the use of this image, not just one time, but essentially web use, print use, brand identity, product placement, all this other things. So you can come up with, some models where that would be quite a bit of money. But under the Copyright Act, you also get the profits of the infringer. And to make it even better, all the copyright owner has to do is prove the gross receipts. So all we would have to do is say, unfortunately, there are these wonderful records from the ATF about anytime you bring liquor in, they've got to declare it. It's a great record. So we could say, okay, you sold 300,000 cases in this year of this stuff, and here's how much you received for that. That's all I've got to prove to the attorney for the copyright owner. They then have to come in and prove, and they have the burden of proof on this. They have to prove all their expenses, and if they want to try to claim that, well, the reason we made this profit was really due to something else, then they've got to put on evidence to show what that other thing was, and that was the real reason why they made the profit. If they fail on their proof, for whatever reason, then the amount of gross receipts stands as the measure of profits. So it can get really, really nasty. I'll tell you another thing if we've got time on that. In addition, because they're importing this stuff, we could have gone to customs and essentially had them stop the stuff at the border. It's even worse, because remember what I said about each vending, each sale of an infringing copy is an act of infringement? Unlike patent world, where you get what's known as the doctrine of patent exhaustion, whereas if you sue the first guy in the chain and recover against him, then people downstream from him, generally speaking, are going to be off the hook. Not in the world of copyrights. Everybody in the chain is committing infringement. And what broke their back in that case was I essentially said, oh, by the way, next week we're going to start taking depositions of Specs and Richards and all these other liquor stores. And of course, they can see where I'm going with this. If I bring those people in and say, basically, tough toenails, it's strict liability, and now I'm going after your profits on the sale of all this stuff, they're going to turn around and try to put it back on the distributor. And not to mention the fact they're not going to be real happy with this distributor for getting them into this in the first place. And so as a result, that case went on the settlement. I can't tell you anything more about that, but we're all smiling. Give you another example. In the area, just to show you the kind of difficulties you can get into on this. I mentioned I do a lot of architectural stuff. One of my first cases was against Phillips. Long time. They had when you're dealing with architectural considered the architectural work. That's what's protected. Okay? And therefore, each iteration of it, the plans or the building itself, is considered to be a copy of the architectural work. So therefore, if you, for example, have kind of the bread and butter one where, you know, the builder sees, hey, they're building a lot of those houses over there, that's a neat design, take the handout, get your draftsman, draft it over and start building it across the road, which happens a lot. Each of those infringing houses that they build are considered to be infringing copies. And so therefore, on the return to the copyright owner, all I have to prove is how much did you sell each one of those houses for? Yeah. Now, there was a case I had on those in which there were over 15,000 houses. And figure on that particular case, and without getting into anything that's covered by a protective order, I can tell you that in that case, the publicly filed documents from the infringer indicated that their average house in those years sold for about $250,000, and their average margin was about 10%. Yeah. Now remember, all I have to prove is the gross, and you do the numbers, and you can see why this can get real interesting. And then on top of that, had they not settled, how about all those homeowners? Remember what I said about each sale is a fresh act of infringement? Yeah.
Would you also do it federally filed copyrights?
Yeah.
Which, that is a whole other.
It's another aspect of it, but you have people talk about registration. Sure. You talk about that, you always have, regardless, you always have the ability to go to actual damages plus infringement profits. In many cases, that's not your best way to go. You hear people talk about, I want to copyright my book, or I want to copyright my code. What they really are talking about is not, you know, having a copyright. You have a copyright from the moment of fixation. It's if you register your copyright with the Copyright Office, and that's incredibly easy to do. I teach my clients how to do it so that they will do it more. It's cheap, it's easy, it's like $35 plus you get online and you do it. It's very simple. If you have registered your copyright before the infringement starts, then you're also eligible to take as an alternative to actuals plus profits. You also can ask for statutory damages. And that's the thing you see at the beginning of the DVD about federal law provides severe penalties for copyright infringement. That can be, if it's for simple infringement, anywhere from $750 to $30,000 per work infringed. Okay? If it's willful, you prove to a jury that they deliberately did it, then that can go up to $150,000 per work. So in other words, let's say, for example, going back to my house example, if there's one model house and they did 10,000 of it, I don't get the possibility of 10,000 statutory damage awards. I get one, because there's only one work. And depending on what the jury had for breakfast that day, it might be $750 or it might be $150,000. So you know, it's very iffy. On the other hand, if you look, for example, at the Napster cases and the cases involving downloaded music, that's where those things get out of control because, okay, if it's 1,000 songs on somebody's hard drive, even if you get the minimum of $750 a pop, that's $750,000. And that's how those cases can add up. Additionally, you have to have, if you have registration before the infringement starts, you can ask the court for your attorney's fees. It's discretionary with the court. They usually will give them to you if you've got it. But one thing about copyright lawsuit that's different from just about most other things you'll see in the U.S. system, though, is that if you file a copyright lawsuit and you don't prevail for whatever reason, then the other side can ask the court for their attorney's fees. And the courts usually grant them. So, again, if someone comes to me, I will generally tell them, yes, I can do this for you, but recognize if for whatever reason this goes south, you may be paying the other side's attorney's fees, and that's going to be substantial. So there's kind of a little bit of a built-in check on, you know, You don't see the kind of copyright trolling that you've seen in some of the instances on the patent side. And I think part of the reason is that there is that built-in, if you will, almost presumption that if you lose, you're going to have to pay the other side's fees. And maybe that's a remedy that can be added into the patent system. We'll see. That's for other members of the, yeah.
I was wondering then, what is the legality concerning the time between infringement as a witness and when infringement is filed, or a suit is filed? Because I can see a situation where someone who's been infringed upon allows the growth process to be generated, and then...
Good question. It's a very good question. The usual answer to that is there's a 3-year statute of limitations under copyright law. You've got 3 years from the time that you knew or should have known the infringement to file a lawsuit. The Supreme Court right now has a case under submission that all of us are waiting with bated breath. What you're really talking about is the common law defense known as laches, which means that you deliberately delayed or you unreasonably delayed in asserting your rights, and as a result, the defendant suffered prejudice, usually by the loss of evidence or something like this. But it could be that you essentially let the damages run out. The general rule in most circuits is that you can't use latches to shorten limitations. Congress gave you 3 years to file a lawsuit. As long as you file a lawsuit within 3 years, that's it. So you could theoretically let things go for 3 years, let the problems run out. I would not advise doing it because courts find out about it. They're not going to like it. They're going to find a way to screw you. But that's how they can do it.
Typically, my understanding is if you have a copyright and you want to enforce it, you believe someone's infringing it, the first thing you do is not usually go and just file a lawsuit. You send a cease and desist letter, and so it kind of starts the process. And so one of the things that I believe you can do with sending a letter, you put the other side on notice, and then you can kind of change the game a little bit, because if they are found to infringe once they get the letter, then it can be willful infringement. So if you sit around for 3 years, don't do anything, all of a sudden file a lawsuit, versus first day you know, you send out a letter, and then by the time you get around to filing a lawsuit, it's 3 years later. You now have 3 years of potential willful infringement, as opposed to just 3 years of infringement.
Yeah.
And that can make a big difference in terms of once you finally file a lawsuit for being in a settlement negotiation.
Yeah.
Well, had I not sent this letter, you would be looking at possibly paying me $100,000. Now it's willful, now it's a lot more. So the other side and what they have to consider facing a lawsuit, they're also looking at very different dollar amounts and trying to figure out how to handle the situation as well. So
Yeah. And again, if you send a C&D, a cease and desist letter, that pretty much does cut off the latches claim. You can't claim that you were relying on the non-action. There are some tactical issues about whether or not you want to send a C&D, especially if you're dealing with form selection. Because once you send a C&D, then you run the risk of the other side filing a preemptive strike to file a declaratory judgment action against you. And so each case is going to be a little bit different, but I agree that usually a lot of times, you usually will send or make some sort of inquiry. Having said that, I've done a lot of them where the first time they heard from me was when I hit them with a lawsuit. It was usually hit them with a lawsuit and say, we're willing to sit down and talk immediately, but, you've been sued. Okay? Yeah.
How does copyright come into play when it comes to professional photography or pictures of other work?
Say that again?
Like professional photography or other work, people know, like photos of art or like building.
We should refer to like the selfie aspect. Who owns the copyright? Who people take the top out and put it up. Correct, Mr. Muskin?
Yeah, like photos of photos of like other artwork that's not there.
That's a tough one. There is a case where there was on a U.S. postage stamp, there was a photograph of the statue of Dr. King on the mall. And apparently when they commissioned the statue, the Department of the Interior didn't get all the rights from the sculptor. He retained all the rights. And so when they then took a picture of that, put it on a postage stamp, he said, hey, derivative work. It's recasting my work in the thing. And Uncle Sam didn't need to pay me, so he filed 4 claims. And the government's response was, oh, but come on. Court of Claims said no pay. Now, one big exception there is if you're talking about photographs of buildings that are visible from a public place. There's a special provision, 17 U.S.C. 120A, that says if it's regularly visible in a public place, no, the architectural works owner can't stop you from making pictures of that. But if you're talking about photographs of, say, a painting that is not passed into the public domain, you know, if you're taking a picture of the Mona Lisa, well, it's already Leonardo, which your copyrights ran out several centuries ago, okay? But if you're taking a picture of, say, a Jackson Pollock piece, his estate can have something to say about that. Yeah.
What about remixing music?
Yeah. All I can say is derivative work. And people in the rap music industry don't like to hear that, but I believe it is. I mean, you can get into a question of what's called fair use, and I can teach a week-long class just on the ins and outs of fair use.
Very good, very complicated questions coming out, talking to several hours.
Yeah.
If
But
it's short enough riff, you can help trigger fair use. But don't
maybe.
count.
Maybe. I mean, well, you've got, for example, when you say short enough riff, you've got the free music case, where that was one where back in the 80s, the makers of Schlitz malt liquor wanted to use a 10-note ostinato from the theme from Shaft in one of their malt liquor promotions. And Isaac Hayes' company said, yeah, it'd be $75,000. And the Schlitz people said, nah, I don't think so. And they used it anyway. And of course, they tried to claim, well, it's just 10 notes. And the court basically said, no, pay the man. You can't do that. It's not how much, it's not how little you use. Now, if you get down to a small enough level, and you get into the fair use factors, for example, is it for educational or commercial purposes? What's the nature of the work? Would it have a commercial impact? All these kind of factors that the court weighs, maybe. But as a general rule, you know, from this copyright attorney's perspective, the idea of, oh, I'm just remixing music. Sorry, you're using somebody's intellectual property without permission or paying for it, and that's infringement. Yes, ma'am.
I was actually curious about that too, like, if an artist were to die, like they wrote to the entire song, they had all the rights to the song that they had, could the rights to that song go, their estate?
Yep. Yep. It has to be a statement. Indeed. How long does the copyright last? Thank you, Disney, but they now last essentially the life of the author plus 70 years. Or if it's a work for hire name.
So he knows to spawn it.
Yeah, but don't count it. They'll probably get their lobbyists to extend it even further.
It's no trademark.
Yeah, look, I'm as full-throated an advocate for the rights of copyright owners, but even I have to say the term copyright has gotten totally out of control, and they really need to bring that back. People are preaching on that. Yes, sir.
The ability to assign for an author to assign his rights away or to sell it.
Some block people.
With it reverting back to those Northmen.
Yeah.
There's a limited.
There's a window.
Protection for authors. There's intended protection for authors and artists who are starring artists and authors who produce things and then kind of just to make it a little bit of money, give it away, and then after a certain amount of time it becomes really popular that they can get it back for their heirs, their children or wives can get it back.
Yeah, there's a window, and I have had my copy of the statute to look at, because this is kind of an unusual scenario. But there's some people that's all they do. But there is a provision where after a certain amount of time, even if you have assigned away your rights, you basically can get them back.
This is a new phenomenon.
It's very new, and it's partially because of the length of time that they got on it. But it's the last one, incredibly long time. Okay, yes, sir.
So what happens when you post a video on YouTube and you have a music track going up the back? Maybe you happen to videotape somebody who's playing some music, provided that you're not trying to collect address, would you still be applicable for that?
Yes.
Yes.
In short, in look at it is the first work that was actually published, if you will, first cut. That's what was released, they got a copyright on this. They then do a director's cut. They could copyright that as being a derivative work. I think that's how you probably do, even though they were, if you will, drawn from the same massive images on the cutting room floor. I think that's how they would analyze it. You would still have the same coverage, because even, I mean, the usual rule on derivative works, let's say, for example, that you create something, and with your permission, I do a sequel, okay? The changes that I make, I own the copyrights to, but the underlying expressions, you own the rights to. Whereas the studio making both of them, it doesn't matter, they own the whole mass. Anyway. Okay, yes, sir.
Now, we're talking about, since we have this, where you cannot play with teenage young, could you possibly copyright or patent a certain sequence that you put together as a video, which is technically kind of a real thing, but not really? Where does that fall under?
Well, in terms of patent, I'll leave this to these guys, but I know there's been some recent stuff on this. In terms of copyrighting a genome, I don't think so. You're not, you could, it's like trying to copyright a recipe. You know, that's not copyrightable. What your typeface that you use to do it might be, and the ways that you lay it out in a literary work is, but the underlying, you know, idea or the underlying discovery, that's not copyrightable. It's not an expression, that's a fact.
The good transaction attorneys are going to try to find some way to protect that, and then come to Mr. Bonham to find some way to prosecute that. If that's the case, that's the expression there.
Yeah.
In the case of patent